Alex here with part 53 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over, however, are number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. That stuff out of the way, we can go into the mindset that I had at the time of the court's order in my case against the Secretary of State. I can recall this period of time as being one where I was mostly unsure of what to expect. I feel like I wasn't getting what I wanted from either court, at least not entirely. When it came to my child custody judge, I felt grateful that I was able to get joint physical and joint legal custody. However, it felt like it was just on paper. It didn't feel like it was real because of all of the lengths at which my ex was, because all of the actions my ex was taking to frustrate those rights. So, in other words, the court gave me on paper joint physical and joint legal custody. However, she wasn't letting me participate in appointments. She was, playing games at visitations and exchanges. There were a lot of smaller things going around or occurring at this time, mainly with regards to right of first refusal. And that actually is covered in a separate video, so I won't talk about it much more. But I didn't feel that the situation was much different in this case either. I was able to get the Secretary of State forced to respond and participate in the lawsuit, but at the same time, the situation in this case was starting to look bad because I had gotten an answering brief from the government which felt unfair. It attacked what I felt were technicalities. However, I've explained numerous times throughout the series that fairness does not prevail over the law. In fact, I even have a video on the topic, fairness versus the law. And I think deep down I knew that I was going to lose the case when I read their petition. I felt like it wasn't fair. I felt like I shouldn't lose the case. But I felt like the argument that they were making, it appeared to be consistent with the law. So all of that being said, we can now go ahead and take a look at what the judge has filed. Here we have the order denying judicial review. Scrolling down, we can see that this judge, like the other, introduces or includes an introductory paragraph which identifies myself as the petitioner, the Secretary of State as the respondent, and indicates that he has considered all of the papers and pleadings on file. And he finds that the Secretary of State did not abuse its discretion in the issuance of a fictitious address to my ex, and therefore my petition for judicial review is denied. As I mentioned, this is brought up on appeal later, and it is determined that the Secretary of State could not have abused their discretion because they don't have any discretion at all. In other words, Secretary of State is not really allowed to exercise their thinking power in a situation like this. They were forced to issue the address. And I, of course, talk about the other approach I take at attacking this problem in previous videos, and I do eventually win this case, but it is a different action that I bring to court. It is not a petition for judicial review, it is a petition for writ of mandamus. It might sound annoying to people that little details like that matter, but our courts do think that that kind of stuff matters, and if we don't bring the correct vehicle, or if we don't use the correct vehicle, that's the phrase I use, then we aren't going to be able to get the relief that we might be entitled to under the law. So let's go ahead and see if there are any details in here. Oh, that's it? Wow, that was short. I did not look at this ahead of time, and I did not expect it to be this short. Certificate of service indicating that the judicial assistant is mailing this order to me, and that's the end of it. You know what? It would have been better if he went into some detail. So, I mean, I feel like this is the kind of stuff that really irritates people who represent themselves. I talk about this problem in the video self-representation bias, how judges will do certain things with non-attorneys that they won't do with attorneys. I feel like with an attorney, he would have probably explained a whole lot more, but he didn't. He didn't explain hardly anything. In fact, this response is probably what triggered me filing an appeal. I probably felt really cheated. So I really did not look at this in advance, guys. I just looked at this just now as I was starting the video, and I'm surprised it's just a 2-pager. I talk about the problem of not understanding what the court intended to convey in the video, getting explanations, but I'm not sure that that video will really help give any kind of advice at all to people when you literally get a 2-paragraph response from a court on your petition. Let's go ahead and take a look at the next document. Notice of entry of order. These have come up a bunch of times in my child custody action, and here it is again in this action against the Secretary of State. As I mentioned in previous videos, this is not what it seems. Notice of the entry of the order was actually already provided by the judge. In fact, I went over in that previous document. The administrative assistant mailed that order to me. So the point of this specific document is to create a source. The point of this document is to trigger a deadline. And I'm not going to go ahead and talk too much more about that because I have a video dedicated to the topic. That video is titled Notice of Entry of Order. And in that video, I explain precisely how the filing of this Notice of Entry of Order triggers the deadline on when somebody can, the deadline on how much time somebody has to file a notice of appeal. And this is, of course, the order denying that we just went over, so I'm not going to go any further into this document. Going into the aftermath, the court has disposed of the petition and thus the entire case by denying that petition. Going into the financials, I didn't prepare any of these documents, so I incurred $0 in costs. The government prepared only the notice of entry of order, and that is a free filing, so they incurred $0 in costs as well. I didn't have an attorney, so I incurred $0 in attorney fees. The government would have probably spent very little time reviewing that order denying and even less time preparing the notice of entry of order. It was a very short order. So I'm going to say 15 minutes for both of those documents combined, which at the rate of $250 an hour is going to bring their attorney fees at $62.50. If you have any questions, as for my previous videos, I'll take a look down in the comments below, or you could send me an email at admin@theproperperson.com.